Akisaidia huyo aniwekea huko mbele. Demo ataniwekea kweli.
on one side to allow the gallery. Kindly. Please, tusonge upande mmoja watu wa media. Please. Mtasonga upande mmoja nyote. Seriously, I'm talking to you, the media people.
Nicholas Mkomo mkali Wisdom na James Mwanungu. Nawapa nafasi kwa magari. Roslyn Wanjiru. The branch of the main force. Amor Omar Ali Abdurrahman.
Simpa kau uliingia lini? Asubuhi. Nilitoka kule jana usiku. Nimekuja na ndege.
Before I give you the hold on. The affidavit is dated 4th of May 2023 and sworn by Mr. George Muyuki, one of the lead investigators in this matter. Your Honor, the investigations are still ongoing. Give me a minute.
Your Honor. In fact, I want you not to even read it.
Yes, 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 I'm there.
Yes. You know, this is the matter that you had already made a decision on the last time we were in court. I believe that if the state wants to reopen up this matter, and they are coming by way of an affidavit, they should seek leave of this court, first of all, to file in a further affidavit.
Later,
Yes.
I view them later.
Yes.
In response, after those many submissions,
Yes.
then you can state or not. All that
Your Honor, what Mr. Cliff is trying to say is that if they are allowed to argue their application, there is no application before you. The question we are raising is just like appeal. Is there anything before you so that once the court pronounces itself that there is a document before you competent to be submitted on, then they can submit.
But that can very well be part of the response. And the court will make a decision.
We are avoiding the question of content being submitted on. Then we respond on that one. We are simply seeking a procedural question. Once that procedural question is dealt with, then substance can proceed.
Raise your point, Mr. Obuto.
Yeah, please.
You know, we were saying that a further affidavit in a matter that has already been determined by the court cannot be extended by a further affidavit. It does not have a life of its own. The first thing they needed to do was to seek leave of this court, which they have not done. So from the word go, you need to stop them at this particular moment. Your Honor, the application, that the affidavit that is in court right now seeks to ask that the respondent hearing be held for a further 30 days.
That's the problem.
Yes.
You want me to disregard that affidavit,
Yes.
yet you verify the case. How do I do that without going into it?
Well, let us start by the issue that they do not have audience before you without seeking leave to file that affidavit.
Your Honor, to buttress our submission. You know, to buttress that position of my learned senior, Mr. Cliff, or Mr. Meta, courts will only issue orders specifically prayed for the law of such orders an affidavit is evidence. A notice of motion needs to be in place. Supported with the grounds and a supporting affidavit. The law on miscellaneous applications is anchored on the civil procedures. It's nowhere in the criminal procedure code. Therefore, this document is incompetent for this purpose as a document to be presented before a court for the purpose of seeking orders. You know, secondly, the matter before you is 075 is already determined. It can only be appealed against when the timeline set by this court has elapsed. One will review sentence.
One more minute.
Yes. Oh, 1 more minute.
Yes.
Oh. Your Honor, one will only be allowed to review a sentence when it is running on. Not to- the respondent was sentenced, if that is the right term, for 2 days. For 7 days, he has served. If they wanted to review that decision, it could be before the expiry of that time. Lastly, Your Honor, is that we completely object to such tactics by the state completely object to these tactics. I wouldn't want to talk about the content of it, but we vehemently object that let the respondent go home or a charge sheet to be produced before you. Mr. Soro has only one word.
Your name, if I may. The state has run out of ideas on how to punish the respondent. We came here.
Your Honor, we will object to that kind of language.
I am
Your
on.
Honor, I will not let it that go. Your Honor. The state,
We can fight over this for
we
hours.
will fight.
Can let me finish.
Your Honor, don't allow that kind of language to be used in the court. Let us be polite to one another.
Is it okay?
Maybe you all of them, maybe. Let me paraphrase. The state has resorted to shifting goalposts. The ruling that was read by this Honorable Court on the 2nd of May, specifically order number 2, that this matter shall be mentioned on the 4th of May 2023 at 09:00 hours for the state to appraise the court on the status of the investigations and for further orders. The court never asked for further evidence. The status report of the investigations. You expected to come with a charge sheet or tell us that this is what we've done, or give us some evidence. We even support their malicious application to keep holding on the respondent. Such kinds of documents, I want the Supreme Court called order. It is full of sound and fury, signifying nothing. And this court has the powers to arrest such an injustice being perpetrated by the state.
Say just
So you have heard the objections, and in my view, they all have merit. Your Honor, considering the time and the schedules and the need to move, I wanted to say, to request and suggest, Your Honor, that you give us direction so that we proceed, so that Mr. Kipro, though he really has nothing to say, but can say all of it, so that we don't make application, ask you to make a ruling, we come back again, because our interest now is that Ezekiel should not be in custody any longer. The more we take you around, we may end up keeping it long. I suggest that you direct in a manner that we proceed, and finish up, and whatever, and you can even order the strike note of the affidavit, and Mr. Kiprop to say what you want to say, we reply, and we finish this.
Your Honor, the defense is saying, and we hear their various arguments. You have been invited to look at your ruling. It was delivered on 2nd of May, 2023. And particularly, you have been referred to the last paragraph of your ruling, which says that this matter shall be mentioned on 4th of May 2023 at 0900 hours for the state to appraise the court of the investigations and further orders. Your Honor, it is upon this subsection B of your ruling that we are before this court to appraise the court on the status of these investigations, and if there are any further orders that the court will grant, then we will make that application. I'm afraid that is what the learned senior Mr. Pro had started. That is the first thing that in his submission he stated, that the court had directed that we appraise to look at the Constitution, where the Criminal Procedure Code is set on the way we are to move court. And Article 159, Your Honor, if I may read Article 159, which I'm sure the defense counsels are well aware of, and the Article 159 sub-article 2D, that justice, judicial authority is derived from the people and vests in the people by the courts and tribunals established under this Constitution. In exercising this authority, the courts and the tribunals shall be guided by the following principles. Now that moves me to sub-article D, that justice shall be administered without undue regard to procedural technicalities. Now, if the Criminal Procedure Code, which is the basis upon which we come to this court and has the procedures by which we are supposed to move this court, is silent on how we are to move this court, then I invite the court to refer to Article 159, which is the supreme law of the land. And basic law tells us that any other law which is inconsistent with it is repugnant to that extent of inconsistency. So, even as I rest, 1 more minute. Thank you. Even as I sit down, Your Honor, I invite the court to look at that provision in light of the submissions by the defense counsel.
The upshot then is that the objection by the
as I was saying, the autopsy reports that have lately come out from that exercise, the autopsy reports that have come out indicate that some deceased have died from strangulation.
Mr. Kibok, I've heard that.
Yes.
I think you are getting what's in that.
Yes, I just want to...
Unless there is something you really must highlight.
Very well. The important thing, Your Honor, here is that that information which is in the affidavit was information which was not before this court at the time we argued our application. Your Honor, that information has now altered the information that we had before and have created new and changed circumstances. Of the custodial days for the respondents to remain in custody. For the respondents to remain in custody. And to be specific, we are asking for 30 days.
30 days from today.
From today. The other days are lapsing today.
So
the other days that we have been given by the ruling are lapsing today. We are asking for 30 days, Your Honor, from today.
how long has it been? It's been there for 7 days.
7 days.
So I thought it was 37 days.
Your Honor, the application, which I heard you say is res judicata, which is something which has been said, is not actually res judicata. It was not under...
Not for application.
Yes.
I did not say the application for the judicata. Yes. I said do not bring up any issues that would otherwise be rendered as a judicata.
Very well. Now, that application, one of the statutes which was premised on that application is Pensions of Terrorism Act. Yes. Particularly Section 33, the state can request up to a maximum of 360 days. Your Honor, we are before you and asking for 30 days. I will leave my colleague, Mr. Simbi, to address you on the authorities that we have relied on to purchase our reports and the changed circumstances that is now developing.
Thank you, sir.
Before that, so now which is you're basically through what I'm saying here.
Yes.
You're not basically investigating the offense or offenses of murder.
Yes, based on what is coming out.
Yes.
And
But
yes.
I'm wondering
Yes.
whether murder then falls under order. Although you have presented the application
Yes, but we are not limited to murder and law.
I'm looking at your affidavit.
Yes.
Because that is the status that I expect.
Yes. And in our application, which we captured in your ruling, we are also investigating other organized crime. Yes.
Yes, Your Honor. You know what the state is telling the court is not new. Yes, I have shared the extra copies.
Oh, you're doing it now?
No, I have shared it.
We have been given right now. This is practice. We have
And I'm only going to refer to a few lines of those authorities. They can easily.
It doesn't matter. As a matter of
Cut us.
After we will prepare our science, it is not fair.
I agree.
Yes. And even look at the same act you're looking at, water.
Yes.
It says, does it say that the application, whatever application, and even whatever you're supporting to do, must be supplied to the other side. The same act you're doing now.
That's right.
Proceed.
Right. So, you know what we are telling the court?
The copies for the copies. So just one of them.
Yeah, true.
I also don't have beyond.
But the second authority largely backs up the provisions of the first authority. But basically, Your Honor, what we are asking the court is not something that is new. We are not asking the court to do something that is out of its purview. Your Honor, in miscellaneous criminal application number 162 of 2019, that is Mutar Ibrahim Ali versus the Republic. At page 2 of the authority that we have just submitted, I will invite the court to look at paragraph 12, line 7, which I will just, page 2 of 3 in Mutar Ibrahim Ali versus Republic. I invite the court. Sorry? Yes. The one that cites Republic versus Diana Suleiman Said and another. From paragraph 10 up there, and I will just quote briefly without going entirely through the entire authority. It says, with respect, I do not agree that the review of bail on the ground of changed circumstances or changes in the circumstances of the case, including circumstances of the accused, witnesses, victims, or the society affected by the alleged crime, is a strange phenomenon. I would say our courts do it every day when we seek to consider renewed applications for bail, such as when volatility on the ground is established to have ceased, or for the cancellation of bail on account of accused refusal to attend court while on bail, or for other reasons. What my learned senior Mr. Kiprop has submitted, he has invited the court to look at the further affidavit that has been filed, and without going into what is contained in that affidavit, it is the state's position that since the last time we were before you in arguing the previous application, there are circumstances that have changed and that are put in this affidavit that if the court looks through these circumstances, then it would warrant the court to grant the days that we are seeking to enable the state conclude its investigations. Paragraph 11 of that very authority says the change of circumstances test is one of common sense, that where the circumstances of the case are so altered that compelling reasons are disclosed for refusal of bail or review of terms thereof, the courts as a court of justice must reserve for itself a power to revisit the issue in the interest of justice. And this paragraph, if you read further, and I'm sure your Honor will retreat and read this paragraph, it opens this window to both this state, the prosecution hearing, and the window is also open to the respondent or the suspect. And we are telling the court that from the last time we were before you, there has been a change of circumstance that has occurred substantially that would warrant the court to go through and give a directive or give an order for extension of this custodial order. So it is open to either side, but it so happens that in this case, it is the state that is moving the court for an extension of this period. All right. Without belaboring the point, as I finish, paragraph 12, Your Honor, on the first 3 lines only. The learned judge says, I find nothing in the Article 49H of the Constitution or Section 123 of the Criminal Procedure Code to suggest that once the court grants or refuses to grant bail, becomes factus official. It is our submission, Your Honor, that based on the ruling that you delivered the last time we were before you, and in light of the provision of this authority, the court does not become factus official by virtue of the fact that it had pronounced itself to 7 days. This very court still has the powers, in light of the change of circumstances, to extend or give additional days based on aggravated circumstances or change of circumstances.
Change of circumstances?
Yes.
And warrant and review?
And that is it. So, Your Honor, we are relying on that authority and invite the Honorable Court to grant us the prayers as sought. Basically, Your Honor, without belaboring the point, I believe the other authority also speaks to the same authority. So, without wasting the court's time, I would wish to pray that the state be allowed a further 30 days within which to detain the respondent.
Your Honor, the application today has reminded me of things. Your Honor, when I was growing up in primary school and learning the English language, I used to believe that prosecution and persecution meant the same thing. Your Honor, today, in fact, it is confirmed that I was not wrong. Your Honor, we have before you a person who has been in custody for over 7 days. We have before you a person who, when required, over 2 weeks before his arrest to go to the police station and make a statement, he duly complied. We have before you a person who, after an application had been made and you looked at all the circumstances, a decision was made that 7 days was sufficient. We were therefore coming before you today to ask that you close this file and discharge Pastor Ezekiel. Your Honor, and it is my submission that despite everything that has been said, that would be the only logical decision you should make. It is now alleged that circumstances have changed. And a struggle has been made, even by way of affidavit and submissions to demonstrate those circumstances. They are not coming out. What has changed? It seems that the investigations are zero. Even by a mathematical calculation, that is a reduction. And what has changed? The only thing that he points out, because Your Honor, in the application and the supporting affidavit, it was clearly alleged that there had been death from Pastor Ezekiel's church. It was clearly alleged that it was suspected some may have been buried at Shakahola. And the only thing that has happened now, and it was all along expected, is that the bodies that were being exhumed will be subjected to autopsy, such that the result of that autopsy is not something new. It is not something unexpected, and it is not a change. It was clearly a procedure expected. Those are Ezekiel. From and Your Honor, now to drag this one here is witch hunting. Your Honor, is my submission therefore that therefore Your Honor, that there is not a change, and it's not a change, particularly a change that they say should now amount to a compelling reason. Your Honor, the authorities that have been referred to you are anchored on Diana Salim, which, although properly well quoted and citation given, they opted to avail. I happen to be concerned with Diana Salim, And Your Honor, the change in the Anna Salim, which they are not disclosing to you here, is that the Anna Salim had been charged with the offense of murder of one person. Remember the terrorist activities in Lamu. Then investigations revealed the death of other 60 people, such that the change was from 1 count of murder to 61 counts of murder. That obviously was a change, can be described with its most compelling reason. The change here is that all other offenses have been abandoned and they are coming to murder and they now have autopsy results. You know, I like that you don't at all give in to that suggestion. So what Your Honor is next? Your Honor, what is expected of you now is to direct that our client be at liberty, because he has not been charged and there seems to be, other than to persecute him, there seems to be no intention to charge him at all. Secondly, Your Honor, in the event that you feel that you want to give them some more time for whatever reason, though in my view they don't deserve at all, then Your Honor, we urge that you direct that the respondent be admitted to reasonable bail. Your Honor, it's a person you don't even need to ask to deposit cash bail or a surety. He's a non-evangelist. You can only ask him, Pastor Ezekiel, come back here on Monday, and he will come back. Just writes a note and he goes.
So you're talking about Africa?
Exactly, Your Honor.
Or personal bond?
You're a personal bond. Even his word without committing it anywhere, we will still count that. That's all.
Your Honor, the affidavit is very, very clear. It needs days for further investigation. 3 things. Post-mortem. He will not be required to be present when post-mortem will be done, so that you detain him, because he will be required for DNA. His DNA sampling and analysis will be done in government premises to his exclusion. Number 2, Your Honor, they are saying he's likely to be charged for murder. When they decide to charge him, he will be available for that charging. He does not need to be in prison or in police custody for him to be charged. You know what? They are saying that he has a lot of influence. Even those who are dead will still have influence. The influence does not wane because he's in prison. It doesn't. He still remains the most prestigious televangelist in this country. So denying him that freedom does not curtail him. You know, let me buttress. So this affidavit does not provide new compelling reason to keep him. If this affidavit could have said he has contacted so and so and so who are witnesses, deny him. That is not true. 2, he has been found escaping out of the country. That is not here. He has made a new passport to run out of this country. That is not here. There is no compelling reasons to keep him. And Shadrach will deal with the question of the authority of Oscar Sudi on whether that is the only option to detain him.
And I hope you have supplied it on that.
No, we have just been given this application now. And they have given the authorities now. Because their trick was, we asked for time to respond so that he continues being there. You know, let me lay the basis for the application for bail. Based on the circumstances that are there. We are urging this court to grant the respondent bail of reasonable terms and put conditions for him to comply with. This court is clothed with very many powers to put those conditions. You know, I will give verbatim some of the notorious cases. In the ICC trial at The Hague, His Excellency then, President Uhuru Kenyatta, former, His Excellency former President Uhuru Kenyatta, and the current President of the Republic of Kenya, His Excellency Dr. William Ruto, were released on board, on bail. Their influence, first is a shadow, is an entity. They were released. And they were doing their matters, and the offense they were likely to be charged is genocide. The offense now has become, I come back to this country. Governors, Obado, the case is there, Governor Obado, Governor Waititu, Governor Lenkorol.
I think as you submit,
I'm only giving.
No, as you submit, yeah. It will be appropriate if you are relying on decisions of the court to rely on actual decisions.
Yes, yes.
And not what I read in the newspaper.
We'll give the citation. Shadrach will give you the citation. As I'm saying, our team is capturing the citation. All those people were released on cash bail. And the witnesses were employees of the county governments. Serious employees directly. They were all released on board. So the question of influence does not matter. You know, in the celebrated case of the DCJ, Justice Mwilu, the Deputy Chief Justice, who had massive influence in the judiciary, she was released. She was never detained. So, Your Honor, this is clear as Magolo puts it. A persecution intended to destroy his church, intended to take a certain political decision which he has refused.
2 more minutes.
Yeah, which he has refused to take sides. Your Honor, the state, I'll also ask the court to take judicial notice that such affidavits from 2017, 2018 to 2022 August, sworn by police officers on oath, the DPP zoned them and the police officers came in court to swear that they were forced to swear this affidavits. And out of all those anti-corruption matters, the DPP has withdrawn. This is one of the affidavits that after some time, they this officer will come and say, I was told to sign at gunpoint. That damage to that man of God can never be recovered. You know, we urge you release him. Because I know that same DPP will come here and say, we have no change. Lastly, Your Honor, in a matter I am of this SS Special Crime Unit officers, where this officer also comes from, by luck.
The mother pending before court?
No, I'm only, it's a miscellaneous. Simply, I'm only saying that in that matter,
I know, an ongoing
it is an ongoing matter.
are you within?
I'm not going to touch on the merit of it. I'm only putting it that, in that matter, because I represent all the police officers in this country whenever they are arrested. Officers were detained for 52 days with such application. To date, Your Honor, no charges have been preferred. A bold court said, go home, these are the conditions. When the state will want to charge him, they'll charge him. And Your Honor will be seeking that if you agree with us and enter him into bail.
Your time is up.
Only one prayer, orally. Your Honor, only one prayer, that's a prayer I'm only making. That if you agree with us, you give our order that he should not be arrested over this matter. Outside here, the garrison of police officers might be here waiting. If he's released, they arrest him. If it is this matter, we undertake ourselves as advocates, senior advocates, that we will present him to any court when the state decides to charge. That's all, Your Honor. Mr. Cliff, then the authority is shut up with you.
Your Honor, let me start by saying that when we are giving fundamental rights in the Constitution, there are 8 more stories. Article 19 of the Constitution is very clear that the fundamental rights belong to an individual and not the state. An individual and not the state. So the state cannot come here and want to take our fundamental rights and say it is because it is compelling. Article 20, and this is a very important article, sub-article 3. As the court wants to grant the fundamental rights, it must do it in a way or in a manner that wants to enforce those rights. In Article 3, yes, Article 20, sub-article 3, the court, the Bill of Rights.
I know what it states.
Yes, yes. Thank you.
The court should make decisions in a manner that promotes fundamental rights.
Yes. Article 21 then goes and says that all arms of the government, all, including the police, the courts, the prosecution, everybody, are bound by it. And that includes the prosecution. So today they come to court and tell you that they want to ensure that the respondent here today stays in for 30 days. But they forget one thing. Compelling reasons must be proved. Have they given you any compelling reasons? And that's where I want to start. They have not. All they have done in this further affidavit is told you that they might want to charge the pastor with murder, depending on future DNA results being found. How is that a compelling reason? Because for me, that does not meet the threshold. Then they tell you, because he has a church that stands on, as they say in their 65 acres and 45,000 people, he has got a lot of influence. What they have not told this court, how he is going to use this influence to interfere with these investigations. How has he used it? Or how does he intend to use it? They have not shown you that in his time that he has been in custody, the 7 days, he has in any way interfered with any member of the 45,000 people that they are talking about. Any. Or by any other form of influence. Again, then the question will be, is that a compelling reason? No. So on these 2 points, they want you to hold the respondent for 30 days more. Yona, in search of DNA, do they need the respondent? The answer is no. In conducting postmortems, as per paragraph number 7 of this affidavit today, do they need the respondent? And the answer is no. Does he work in any of those institutions so that he can influence them? Again, the answer is no. A compelling reason must be so convincing to this court, such that the court must act on it. It must be convincing, so tying, so, I even love words. But it must convince you. And today we are saying,
The court, Mr.
Yes.
Computer, dealt in detail
Yes.
of what amounts to a compelling reason.
Yes.
Do not believe on that.
Thank you very much, Your Honor. So today they come with an affidavit seeking a fundamental right of a respondent to be held in custody, denying him those fundamental rights by an affidavit without an application to serve. And so as to sneak in some terrifying words, my learned colleague, Mr. Kiprokse, brings in the issue of terrorism and tries to bring it in a smooth way. But look at the affidavit. He only wanted to terrorize us. It is not in the affidavit. So they put this fear into us. And I'm sure this court cannot in any way, in any imagination, be influenced by such an application. It should have been in the affidavit and it should have been articulated. Is there any new information? There is no new information. These stories they bring in this affidavit, yes, I'll take even less. The information that they are bringing in the affidavit today was the information that was actually intensely put in the previous affidavit. The court has already pronounced itself in such a decision. So there is nothing new that has been brought to court today, and this should not take a lot of time for you to make a decision, because it is actually, as my colleague said, hotel, let me give you.
Thank you, Your Honor. For the record, my name is Shadrach Wangoi. And Your Honor, I begin by associating myself fully with the submissions made by my seniors. And I recognize Your Honor coming up. Ordinarily, I will not have much to say. But with that as it may, Your Honor, allow me to mention that the counsels for the respondent take is that we do not doubt the immense powers that you have as a court, powers donated to you by law. Your Honor, there has been mentions by my learned colleagues for the prosecution making reference to a particular precedent that has been over and above the reference to the Constitution. Your Honor, I submit with humility that it is important that when we are making submissions that involve the application of the Constitution, particularly the question whether there is enough ground to continue with the intention of the respondent, it is paramount, Your Honor, that the court also reflects on a book written by Ronald Dworkin, Taking Rights Seriously. Your Honor, your ruling of the second day of May 2023 essentially limited the freedom of movement of the respondent. You gave the applicant an opportunity of utilizing the evidence that they had already collected to take any adverse or whatever action that is there against the respondent. Or looked at it differently. You gave them the opportunity of going to look for that adverse information or evidence that they can use so that today, Your Honor, we can have at least a closure of the file that we have before you and the commencement of proceedings as against you. Your Honor, we are lucky that our client is, Your Honor, having granted the respondents 7 days, taking into consideration the affidavit that was sworn by the investigator on the 28th day of April 2023, an affidavit that makes very wild accusations, painting a man of God into those Your Honor, the opportunity that you had given to them has not been fully utilized. They brazenly approach you, Your Honor, now not asking for 1 or 2, but 30 days, Your Honor. Your Honor, your point of call of the precedent that was set by Justice Professor Joel Ngugi. Yes, the Oscar Sudi case, Your Honor. And with humility, Your Honor, I will remind the court of the double test that my learned judge then set to be used by all. Your Honor, the first of that test, which the court, I am very confident that the court has interrogated these issues even before.
The case of Oscar Sudi.
Yes.
I'm quite familiar with that decision.
Thank you.
So you don't have to go into it.
Yes.
Unless there's a particular issue you must highlight.
Yes.
Yes, I well know that decision.
Yes, Your Honor, I make reference to the double test, especially by likening it to the facts that have been referenced. Yes.
I read the history.
Yes.
Yes, because the magistrate that handled it.
Yes.
Before. Yes.
Indeed, Your Honor. Your Honor, it is important that we consider entertaining the application that is made by counsel for the prosecution to interrogate the facts. My senior, Mr. Magolo, made at least analogy or submission with regards to circumstances before and now. The court might take judicial notice of is that the man who has been likened or associated with the respondent, one Mr. Paul, his house was torched. That is an important circumstance that happened post his arrest. The court might want to ask what became of the respondent after his arrest and detention. Your Honor, his followers have been flocking the court compound. The court every morning has been treated to religious songs and dance. Your Honor, that does not speak of circumstances that will warrant the continued detention of the respondent. In any event, Your Honor, I'm not shy to submit that the prevailing circumstances, Your Honor,
I'll give you 2 more minutes.
Thank you. The prevailing circumstances, Your Honor, point to a man that is deserving of an order of discharge, or at the very least, on some reasonable bail or bond terms. Your Honor, in closing, I must mention, Your Honor, we are living in a new constitutional dispensation.
13 years later.
And I am sorry and I regret, Your Honor.
I hope you are not one of those who first read as the
Yes, yes, yes. We have had the misfortune of constitutional regime. A regime that did not even entertain the thought of a person accused of murder being released on bail. Looking at the current constitutional dispensation, we should not even be astonished or surprised by or efforts being made by the state suggesting that they will plan to charge him for murder or for whatever offense that is there under law. Because in the name of the Kenyan Constitution, regarding the offense they are charged with, have a constitutional entitlement of bail. And Your Honor, I close by urging the court with humility, Your Honor, consider setting this innocent man free and give them the enough time that they require to complete the investigation. Nothing will change even after the investigations are concluded. Thank you, Your Honor.
Yes, Your Honor. Yes, Your Honor. Your Honor, of interest is the application that was initially brought before me. Just to point out, it was brought under Porter. In such, you know, we sought for time. We have again come to seek for more time. You know, the court found it fit to grant us time in the first instance on reasons that were well canvassed. Today, Your Honor, we've stated clearly, indeed, there is change of circumstances. There are new emerging issues that if time is not allowed to the investigators, you know, we will not achieve justice for the man before you. Two people. We are talking of 100 plus.
You know, the state is such a bureaucracy that knows they are only to respond. I wouldn't want to teach anybody that. Purely a rejoinder on questions of law.
We have a right to respond to issues of law and any other issue that came up. Any issue that came up.
Thank you, Your Honor, for that guidance. And that is the reason why, extensively, the defense used certain words, which, Your Honor, I found them very entertaining to the crowd, to say persecution appear before you, that we can say we are persecuting anyone. It is in the interest of everyone, including the state and the defense, to allow the prosecution, together with the investigators, to come up with any evidence that could be useful to the victims. We say so because at great length in paragraph in paragraph 14, we stated that the rest following, and the following, Your Honor, is not a small following. Your Honor, we are speaking of 45,000 known persons to the respondent, not to the prosecution, not to the investigators. Your Honor, if a man, a single man, has that following, there is nothing more we can speak to explain what influence means. You want to bring it closer home. The defense was courageous enough to tell us outside here, within your premises, the court premises, people are praying.
What they discussed outside, surely you should
It's strange.
I wasn't there, but whatever they told is honest.
I have a
Council says so. Council says so.
Mr. Magono, Mr. Omari, I've not even heard what you're objecting.
No,
He's
he
trying
just
to bring
what he started to say,
Because I do not know what he's about to say.
what he started to say, the way he said it, that I was told outside here, within the premises of the court. Yes, whatever I was told, he does not need to go beyond that.
You know, I said it was said by the defense. Has it also said that there are people singing and praying outside? That is my submission. And if that is anything, you said so. And therefore, Your Honor, that is the same thing, Your Honor. The defense have been saying that prosecution has seen that we are not in a It's all about justice. From the back, that they are outside. Yes.
Not that is in custody. How then does that influence when?
I'll come to that. What Shanzu said, that this man cannot influence. Yes. Secondly, Your Honor,
With some respect, when you call him pastor, don't call him with some respect. Kind. All the rest of it, kind.
I have continuously referred him as the respondent.
Kind.
And on a light note, Your Honor, the Bible calls everyone man.
You have 2 more minutes.
Your Honor, continuously, the defense, in their wisdom, invite you to look at Article 3 of the Constitution and disregarded Article 49(1)(g). That is why we are here. Both articles, Your Honor, must be read together for us to be able to interpret the reason why we are here. And the reason why we are here, Your Honor, is simple. Why we intend to have him continuously to remain in custody. That is found in Article 49(1)(g). We have a Your Honor, if you look at Article 1D of Porter. Yes, sorry, section 33, 1D section. It speaks of the manner in which we can approach the court. Your Honor, we've chosen procedures. That is where the procedure is.
The section talks about an application served upon the respondent.
Yes.
This was an oral.
And the court,
The one today is an
yes,
oral.
well guided. And therefore, Your Honor, we are well guided by that particular section. It states that indeed, as we appear, we have complied with all known provisions of the law. And therefore, Your Honor, it is only in the wisdom of everybody that if investigations are concluded on time and in peace for everyone, including the respondent, that we shall come before you and state as to whether we are, if any, because, Your Honor, there are emerging issues which have been laid out in the affidavit, and those issues are speaking of post-mortem. The defense stated that, Your Honor, there is nothing new post-mortem results.
You are trying to point out?
Your Honor, post-mortem results are very crucial. They are linking us to the cause of death. We intend to have a DNA carried out. That is DNA exercise carried out as soon as possible. It is only fair that this respondent or the respondent, who is a peace-loving Kenyan as they state and a man of God as they state, which we respect, that he doesn't influence the rest, the family members who are relatives, since it is clear that the victims are also followers in his church.
Where do we hear that? That the victims of Shakawala are also followers of the church.
I did not say Shakawala. I'm saying it is only fair that I respond.
You know why? Why we are bitter?
Please take your seat. I'm one of the good victims that you're talking about.
Yes, Your Honor. Very few minutes to sum up what Mr. should have said. Your Honor, one thing that a lot of people do not understand is that prosecutors, by their very job, are ministers of justice. So the issue of persecution, as alleged by counsel, should not arise. Even as prosecutors, from where we seek to establish the truth. But that is on the line.
I do not think
that
everyone has talked about this prosecutor before the court.
No, not this one.
Prosecuting the respondent.
Yes.
I think what they were alluding to is the state prosecuting. It's true, that's the one.
Very well.
Not your office.
Yes. Thank you for that clarification, Your Honor.
So at least that one will understand.
Yes. That I believe if you put it that way, then we would.
I can assure you that that's the one.
Okay. Very well. The most important thing, Your Honor, is how you understood it, and we are glad you understood it. So what our submission here, Your Honor, there is one fundamental question that is being asked: that why do we need another day? That in our affidavit, we have not given the reason why. We did not have an opportunity to state what is in our affidavit because the court already has that written affidavit. The defense has that written affidavit. But for purposes of clarity and record, this is why we request for those extra days. We are saying that when we appeared before you, exhumation was ongoing at Shakahola, and that exercise is still ongoing. And now the second phase was conducting autopsy. We are saying in our affidavit that we have the autopsy results and the post-mortem results have shown that some of the deceased persons died as a result of strangulation and some were killed by blunt objects. That is in our affidavit. So, in light of that, why then do we need the respondent in custody for 30 days? We need the respondent in custody for 30 days for this reason. It is believed that once the DNA exercise is conducted on the bodies of the persons, especially who died as a result of strangulation and some who were hit by blunt objects, there has to be DNA profile by the living relatives. By the living relatives to match if there is a link between those who were murdered by strangulation and death by blunt force trauma.
I think we need to be careful there.
Yes.
Because you are prosecuting your application a second time.
No, you're not. No, we are not a prosecutor.
That is what you are doing, yeah?
Yeah.
Because all this that you are telling me that cut of that.
Yes.
Yes. And I told you,
Yes.
Okay.
I'm much guided. I was only trying to respond to the point that was raised by learned counsel, Mr. Omari and Mr. Ombeta, when they said that there is absolutely no reason that has been given for that detention. But I'm glad the court has taken note of that. Finally, Your Honor, I wish again to respond that we have not charged the respondent at this stage. The question that is being asked and repeated is that we are not giving compelling reasons. We are past compelling reasons. We are saying that there is a change of circumstance. This is different from compelling reasons. We were before you, we gave our compelling reasons. So, Your Honor, we cannot now say that we have not given a compelling reason. Yes.
And now,
yes.
Yes.
I agree. I agree. Yes. And what I'm trying to say is, I agree with you, Your Honor, insofar as that authority speaks about compelling reasons as a result of a change of circumstances. And when no, okay, I will rephrase. The compelling reasons are as a result of the change of circumstances. That is what you think. Which again led to us saying may result to the charge of murder. We are not saying we are preparing, we come out very clearly. We are not saying we are preparing murder. We are saying it can entertain an application for custodial orders even if it relates to the case of murder. It cannot only try the case of murder, but it can extend custodial length even in charges that relates to murder. I beg to see.
Allow me to make 2 points. And just like what the defense has said. Your Honor, I refer to your ruling paragraph 40. In paragraph 40 of the ruling. And the issues raised by defense cuts across what is in paragraph 40. Your Honor, there is a paragraph which says a court case has been made by the respondent for the respondent to be detained on 3 compelling reasons on the possibility of interference with witnesses, the interest of public, and the seriousness in nature of the offences under investigation. You have seen from the above law that any of the 3 counts, page 31 of your ruling. Yes. There is a paragraph, there is a sentence which starts with a court case has been made for the respondent to be detained. The last paragraph of page 31.
The matter concerning the Shakaula massacre.
Yes.
As stated above is one of them.
Yes.
The state act that the respondent may be linked to the same and not informed that it has been proved on a balance of probabilities that there is a possibility that the respondent may interfere with witnesses. For the respondent to be detained on the 3 compelling reasons for the interfere with witnesses, the interest of the public, and the seriousness in nature of the offences given. Now, proceed. Look at paragraph.
I want
you to read them together.
Yeah.
paragraph 41. But then, the specifics of the investigation for the state division to complete, as per the establishment of the state are not disclosed, except for the intention of the witnesses. That being the case, this court will, in the premises, state it that the time sought is for purposes of the recording statements. Yes? In my view, 30 days is excessive, that's not excessive. So, we should leave the two parties.
I agree entirely with you.
You're saying, this may be interference in terms of the recording statements.
Correct.
Yes.
My submission is similar to this issue, that you agreed with us that the three issues have been sufficiently proved to your satisfaction. The only issue that paragraph 41 does is you took your discretion in the number of days that we had requested. We had requested for that days, you gave us 7.
Not quite so. What I did was to talk about the three issues regarding the aspect of the current state. Yes. Yes. So the interference is limited to the aspect of the witnesses recording statements, which therefore I found 30 days is too much for purposes of the recording statements.
And that is, I agree.
Yes.
On the second issue, is the case of Oscar Sudi, referred by Mr. Wambui, on the of the double test. The first test in that
We have known the submissions that they responded to report is a mission not for the country.
Thank you. I'm telling you that they never responded.
Are you deciding?
Bro, function that
tutaelezewa wakati wa ruling and authority.
Bibi hapo.
Voilà. Simpatie